Chapter 6 Jurisdiction of Dean and Chapter and Prebendaries. There are 24 parishes in the county of Lincoln, over which the Dean and Chapter of Lincoln exercise jurisdiction, and there are several other separate parishes, over which the respective Prebendaries who derive the name of their prebends from those parishes, separately exercise jurisdiction. The jurisdictions of the Dean and Chapter and Prebendaries were originally granted to them by Robert, Bishop of Lincoln, about the year 1160, to exempt them from archidiaconal jurisdiction, and their appeal is, by the statutes of the Church of Lincoln, reserved to the bishop. The present practice is in accordance with the original grant, and their jurisdictions are inhibited for 3 months once in every 3 years, at the time of the bishop's primary and triennial visitations, and all jurisdiction in them is, during the inhibition, exercised by the bishop and his chancellor, but during the remainder of the 3 years, the Dean and Chapter and Prebendaries exercise jurisdiction in their respective parishes. According to the case of Bear and Biles v. Jacob, Hilary Term, 1829, 2 Haggard's Reports, 263, these jurisdictions are not peculiar and exempt jurisdictions, but subordinate to the bishop, and in relation to the jurisdiction of the prerogative court, in cases of bona notabilia, can be considered only as a part of the Diocese of Lincoln, and when persons die or leave bona notabilia within such jurisdictions, their wills or administrations cannot be subject to the prerogative court, except where such person shall leave bona notabilia, or die within some peculiar belonging to the Archbishop of Canterbury, or within some peculiar belonging to some other diocese, or within some other diocese than the Diocese of Lincoln. See, however, the subsequent inquiry into the nature of peculiar and exempt jurisdictions. In case of a person dying within one such jurisdiction, or within any commissarieship or archdeaconry, and having goods to the value of 51, in any other such jurisdiction, commissarieship, or archdeaconry, there probate of his will, or the administration to his effects, should be granted by the bishop, or his chancellor. For a probate or administration so granted will be effectual throughout the diocese, but a probate or administration granted by the official or judge of any such jurisdiction, commissarieship, or archdeaconry, will be of no avail beyond the jurisdiction within which it is granted.